Thank you very much. Yes, much of this conference is about our standards and regulations, which are, you may have heard us mention it just a few times, coming in on the 25th of November. You have heard from Paul what, at a high level, our reforms are about. As he said, this is about removing prescription, detail and unnecessary bureaucracy. Detail which is costly for firms to comply with, and where there's a good chance that this will be passed on to clients. It's also about making our rules shorter and much easier to navigate and understand, making sure our focus is on high standards of ethical behaviour, and giving you greater freedom to use your professional judgment, and greater freedom about where and how you can work. So what I want to do in the next 10 minutes or so is quickly run through some of the key areas of change to show how we've approached achieving these goals in practice. The 5 key areas I'm going to cover are the new SRA principles, our new codes of conduct, our updated enforcement strategy, our new simplified accounts rules, and our more flexible approach to practising rights. This will necessarily still be at a pretty high level, but don't worry, because there will be a deeper dive into each of these in the marketplace and breakout sessions throughout the day. So starting with the SRA principles. These are the fundamental ethical principles we expect everyone we regulate to have as their core values, such as independence, honesty, integrity, diversity and inclusion, and the rule of law. They apply in and out of practice where the context permits, and our new enforcement strategy, which I'm going to talk about a little bit more in a moment, helps to explain how we approach that. There's been no major change to the principles, but you will see that there are fewer than there were. And this is just because we felt that some of the existing principles sit better in the codes, which apply to your practice and how you work. So that includes principles like the obligations around providing a proper standard of work, managing your business, and cooperating with regulators and the Ombudsman. The principles have been rewritten in a positive style and format to emphasise that these are standards to achieve, not rules not to break. So, for example, we now say that you must act with independence rather than don't allow your independence to be compromised. But that doesn't make any practical difference to what we expect you to do or our enforcement approach, because, for example, if you take the principle of acting with honesty, if we prosecute a person for not being honest, then we need to prove that they've been dishonest. So in effect, that makes no real difference to our approach. And on the subject of honesty, this is now a separate principle from the concept of integrity, reflecting the case law which clarifies that these are different words which mean different things. That's something that might seem obvious, but the courts have spent some time on this question and have now confirmed that the concept of integrity is wider than just acting dishonestly. So, breaching the principle of integrity could involve taking unfair advantage of clients, or willfully or recklessly disregarding rules or ethical standards. And as you may have seen in the media coverage, the Solicitors Disciplinary Tribunal recently made a finding of lack of integrity in a case raising allegations of a sexual nature. Together with the new standards and regulations, we have published guidance on acting with integrity to help people understand what this principle means. It's quite a useful summary. It runs through the way the courts have approached this and some of the case law. So if you're interested, I'd encourage you to have a look at that. Moving on to the codes, the first big change, as Paul mentioned, is the fact that we now have 2, one for solicitors and one for firms. We think that this will make the personal obligations and standards of professionalism that we expect from solicitors clearer, with one short document that's easy to read, easy to understand and internalise, and which applies to all solicitors wherever they work. And this, we believe, will redress the balance for those working outside law firms. There's currently 31,000 odd of us working in-house, and we believe it'll correct the perhaps understandable perception that the code isn't relevant to us currently, as well as addressing the misconception perhaps held by those working within firms that compliance is a matter for their firms or their compliance officers or someone else. So that's the individual code, and the code for firms sets out the standards and business controls expected of firms, as well as the role of compliance officers within those firms. And across both documents, we have got rid of the indicative behaviours. These are those numerous non-mandatory examples of how you might comply with the outcome set out in the current code, and which have often been viewed as lots and lots of detailed rules which must be complied with, rather than non-mandatory guidance. And that means that the codes are simpler, and that we're putting trust in your professional judgment to assess the right course of action depending on the specific circumstances you're facing. Clearly, not all of which we could cover in indicative behaviours, even if we wanted to. But removing the indicative behaviours doesn't mean we've abandoned providing guidance for you. Instead, we've developed a range of resources, including more use of case studies designed not to tell you what to do, but to aid your thinking, particularly on the grey areas. And if you want to hear more about some of those grey areas or to raise specific questions on points of detail, then do please go along to the relevant sessions today. And as a shameless plug for my session, there's one specifically to cover compliance queries, which will be in the breakout sessions later. Or please do approach members of staff who'll be happy to help, and if necessary, take matters away and come back to you. One really key piece of guidance is our new enforcement strategy. We really do appreciate that with the flexibility inherent in our new approach, people are anxious that we're going to try and catch you out or second guess you. And the answer is that we really are not. We are putting more trust in your professional judgment. But we will expect you to be able to account for the decisions you make against the principles and codes, so how you apply them to the particular issue you're facing. That means if you're making a judgment that you think isn't clear-cut, then you'll want to record how and why you made your decision so that you can account for it at a later date if need be. And if you're unsure, then yes, there are the particular codes and principles and supplementary resources, but an important place to look is at our enforcement strategy, which underpins all of our rules and regulations. It aims to provide clarity on what we see as serious and why and when we take action. And it makes it clear that when we are taking enforcement action, we will focus only on serious breaches of our rules and requirements. And that means those that present a risk to clients or others, or to the public interest, which is the interest in the rule of law and administration of justice. So what I'd like to do is to reassure you that this means we won't take action where a genuine mistake has been made or where there's been a judgment taken in good faith for valid reasons. We developed the enforcement strategy on the back of our Question of Trust campaign, which sought the views of around 5,500 members of the public and the profession. And it sets out some of the factors that do affect our views of the seriousness of a breach, such as the explanation or motivation for a solicitor's actions, any likely harm caused by those actions, the vulnerability of the clients in question, the seniority or experience of the individual, and whether this is part of a pattern of behaviour or not. And on private life, which I touched on earlier, the strategy explains that we're interested where something indicates a risk to the practice of law. For example, the misappropriation of funds when holding a role outside of practice or an appointment. Or if the conduct is so shocking that it undermines public confidence in the profession. And some of the recent cases of discrimination in social media are examples of that. So what does this all look like in practice? Well, we've published some guides on our approach to certain issues and the mitigating and aggravating factors that we take into account. These include issues we regularly deal with, like offensive communications and social media, but also drink driving, competence and standards of service. One other area where we've already published a number of guidance documents and on which we've got a dedicated breakout session later is the new accounts rules. So just briefly in this forum to highlight that this is a key area where we've removed prescription, reducing the rules from something like 40 currently to less than 10 pages. And that's in order to really focus on what matters. So the core protections, vital to protect client money and keep it safe, remain. So for example, returning client money when you no longer need to hold it, keeping good records and reconciling accounts regularly, and never using the client account as a banking facility. But we've taken out things like strict time limits, such as the 48 hours to transfer money for fees or professional disbursements, and the 14 days to separate out mixed payments. These are artificial deadlines which we know can cause difficulties, for example in rural areas where people are having to make regular and long trips to pay checks into the bank. The important thing is for money to reach the right place promptly, so we've replaced this with a rule that says so. We've also introduced flexibility for certain types of business to facilitate alternatives to using a client account. So for example, when the only client money you're holding is for your fees or professional disbursements, you don't need to hold that in a client account, or where you feel a third-party managed account may be more appropriate for your business. As I mentioned earlier, there's a dedicated breakout session on the accounts rules if you have any questions or are interested in hearing more about that. Paul's talked through why we think giving solicitors more freedom as to where they work is the right thing to do. This has at its heart a balance between flexibility and choice in the market and the protections attaching to regulated legal services. So we've put in place provisions to help try to get that balance right. For example, if you want to provide reserved legal services to the public outside a regulated law firm, you can do this as a freelancer, as Paul mentioned. But this can only be done if you're genuinely working on your own. And this means, much like a barrister at the self-employed bar, having no employees or partners providing the services alongside you and engaging directly with the client, not, for example, through a service company. And in addition to that, you'll not be able to hold client money other than for fees and disbursements ahead of a bill being delivered. You will have to have adequate and appropriate insurance in place, and you must have been practicing for at least 3 years. In terms of offering unreserved services, you can do this from an unregulated organisation, and that could be anything from an accountancy firm to an HR firm. Commensurate with the fact that these are services that non-lawyers can provide at the moment, there are fewer restrictions. But the Code of Conduct, of course, applies to the solicitors' work wherever they practice, and solicitors in unregulated businesses won't be able to handle client money to do the work. But most critically, solicitors working in this way will need to be totally upfront with potential clients about the protections they have and don't have compared to a regulated law firm, including information about the indemnity insurance arrangements that they have in place. Again, we've published a range of new guidance to help solicitors and unregulated businesses understand what they need to consider if they want to work in this way. And there's a lunchtime session specifically on this issue, so do go along to that if you want to hear more. Finally, as Paul said, we think these changes are more about opportunities to work differently than about introducing new requirements or compliance systems. So if your systems are compliant now, they're most likely to be in the future. But there are a few things I'd recommend you do to prepare for the 25th of November. So firstly, to check if your documents, systems and processes do reflect the new standards and regulations. And there might be opportunities to do things differently. So you might want to review these to have that in mind. Have a think about what an approach of less prescription means for you and your firm. This really does allow greater opportunities to use your professional judgment, but you'll need to make sure that you and those within your firm can justify the decisions that you make. Does everyone in your firm understand the key standards that apply to them? And have you read the enforcement strategy and understood the new reporting obligations. Every solicitor has a responsibility to report concerns to us promptly where you reasonably believe that events that we would class as a serious breach have happened. And finally, does your website display our clickable logo? I'll hand over to Jane in a moment, who'll share more detail on that, but the logo becomes mandatory for firms from 25th of November. So that was a whistle-stop tour, but we've published a range of support to help you. A one-stop webpage, the web address is on the slide, which has a whole package of support in place, links to guidance, webinars, videos, graphics. We've also worked with more than 2,000 solicitors to develop an easy-to-use, up-to-date web version of the rules, with links to appropriate supporting materials, guidance and glossary definitions referenced against the relevant rules. And finally, if you're ever not sure about something, please do phone our ethics guidance helpline who can offer you support. So now I'll hand over to Jane to say a few words about our reform centred on better information for the public.
Good morning, everyone, and thank you very much, Juliet. So I'm going to talk a little bit about better information this morning. I understand from colleagues that about half of our attendees today have been to our compliance conferences before, so I'm very pleased we've not actually put you off, but that also means you're likely to have heard me talking about this over the last few years. So just reminding ourselves what the problem was that we were set out to solve. So as Paul's mentioned, back in 2016, the CMA undertook a review of the market and concluded that a lack of information was one of the barriers between people and accessing the legal services that they needed. And we know that 9 out of 10 members of the public and 9 out of 10 small businesses just don't come to regulated legal professionals when they've got a problem. And that's a real challenge because there's so much evidence that outcomes are hugely better for people if they do get the help that they need. People want to shop around, but at that time only 20% of firms were actually providing pricing information, and they were providing it, they told us, because it gave them a real competitive edge. So we needed to take steps around that to close that information gap, as Paul's mentioned, so that people could see that law firms and what you were offering were accessible and relevant to their needs. So we put in place a range of steps, and I'm going to talk about what we're doing in a moment, but just picking up the requirements that we placed on you all the better part of a year ago, which was to publish pricing information, but also a range of other information, including how to complain to the Legal Ombudsman. And just to remind you all that the Legal Ombudsman have a stand here in our marketplace today, so do take time to go and talk to them. So we've undertaken some web sweeps of where firms are up to in terms of meeting the obligations that we've placed on you all. And it's good news. Most people are doing the right things. Over 80% of firms are either fully compliant or doing everything they can to be compliant with this. We've got another shameless punt, breakout on this, Hall 10, where we're going to talk you through some of the detail around that and where people are falling a bit short, for example, in talking about VAT on costs and disbursements. So a good opportunity to talk through what all of that means. But this has been in place for about a year, and there are some firms that aren't doing enough on this or actually aren't taking the steps at all that are needed. So we do want to emphasise to everybody that this is really key. So please, please make sure that your own firm's website is doing everything it needs to do. And of course, for those firms that want to make sure they maintain that competitive edge, you can publish far more. We've asked for pricing and services over quite a limited area, but there's no reason why you can't share information across everything you do. Moving on to the clickable logo. So the genesis of this is around the recognition widely by the CMA, but I think all of us, that about 25% of the current legal market is in the unregulated sector. So we're doing a couple of things around that. As Juliet's mentioned, we're freeing up solicitors to work in the unregulated sector to try and make sure that members of the public are really getting the best possible service, which is from the people who are best qualified to provide that service for them. But firms and the CMA also said to us that we could do more to highlight the differentiation. And for firms in particular, people wanted to promote the advantages that people have if they use a regulated law firm. So we've introduced the clickable logo. You just pop through it on somebody's website and it helps a member of the public to see what sort of consumer protections are in place if they use your services. The fact that firms are interested in having this there, I think 4 out of 10 firms have already got that up there so that they can show what makes them different. 25th of November, that will be mandatory for everybody. So if you haven't already done so, as Juliet said, I urge you to get that in place on your website. It's very straightforward. There's lots of information on our website about that, and lots of people here today who can help you with that. So I'm going to move on to a new component in all of this. It's something we've been talking about for about 3 years now, slightly quicker than Brexit, but nonetheless. So at the moment, we, the SRA, provide a range of services for people who want to look at the work of solicitors and law firms. Check a Solicitor allows people to look at people's disciplinary records. Law Firm Search allows people to look up a law firm and make sure it is regulated by us. And actually about half the users of that service are other law firms wanting to check that people are everything that they say they are. We get about 2 million visits to those two services every year, so really popular, hugely popular, the most popular services on our website, in fact. But what we don't do is provide an online register of everybody we regulate. And of course, most regulators do. And that means that people will be able to look at yourselves and the type of practice that you are performing, the variety of practice in place. And of course, that lines up with the requirements of the standards and regulations and our new arrangements for solicitors to work in different ways. So really key for that. The data comes straight from my SRA, so make sure your details are up to date in my SRA. This is your information that we will be putting into the register. I should emphasise that this is a validation tool. It doesn't have a commercial element. It's not find a solicitor. It's not a comparison website. It simply allows people to check that solicitors are regulated by us and the detail of what they do. And we'll be doing more over the next year or so to build into it the other lists and registers that we have on our website so that people will be able to see everything in one place. But we didn't simply take the requirements in standards and regulations and put them up there on the website, not least because we need to present all of this in reasonably plain English and help people to understand what we're doing. So we've spent the last 7 or 8 months working with members of the public, with the profession and with others to try and make sure that what we're producing is going to meet everybody's needs. It's currently out in beta in a trial version with our Evolve reference group, which comprises about 1,000 solicitors, and they're giving us feedback on a daily basis. And next week, you'll all get a chance to have a look at it and let us know what you think. So what does it look like? Very straightforward. Solicitors Register is what we're calling it. We tested the names with about 2,000 members of the public. They said this is what they like. That's what we're calling it. Looking here, and this is synthetic model data. I resisted the temptation to use either Juliet or Julie because I thought it would be a bit of a surprise putting up real data for all the other Olivers and Brannans in the room. So any relationship of any of these names to any people living or dead is purely accidental. None of them exist. But the idea is that people will be able to put in names in different variations and pull up the solicitor they're looking for with some really kind of key indicators, which is what people have asked us for. And you can see in the middle there that if a solicitor has indeed been struck off by or suspended by the tribunal, we'll make that clear up front on here. And we'll also be saying where people are actually working. And you can dive into the details. So we've selected Helen Alexander, and if she's in the room, I can only apologise, but this is a made-up name. This is not a real person. But as you can see, Helen is a busy woman because she doesn't just have a regulated law firm. She also works independently as a freelancer, the second bit there, as Juliet's mentioned. But she also runs a niche practice providing non-reserved legal services in IP in this case. And people will also be able to dive into any one of the practices in which you work and get information about that firm in the same way as you can on Law Firm Search, but knitting the whole thing together. So we think pulling all of this together will help to close that gap, as I mentioned, between what people are looking for and what they can currently find. We've got more work to do on this, but this will enhance the reputation of the profession, make you more open and accessible, and of course give all of you the opportunity to use it as well. So what's coming along next? We've got a little bit more to do on this. It will be out there live before the Standards and Regulations go live. We will be bringing law firm search and check a solicitor into all of this. Please do use it to validate colleagues and people when you need to do so. Some of you may want to put a link to it on your website along with your Clickable logo so that people can really see everything they need to know about you. So Juliet and I have talked about what happens in practice. And now I'm going to hand over to Julie Brannan, who is going to talk to us about how people actually come into the profession. Thank you, Julie.
Thank you very much, Jane, and hello, everybody. I'm going to talk to you about some of the work that we have underway in the education and training arena, but I am aware that I am all that stands between you and morning coffee, so I will be brief. Picking up first on the Solicitors Qualifying Examination, you heard Paul a few minutes ago remind you all about what the SQE is. It's a single national and indeed international licensing exam that everybody who wishes to be admitted as a Solicitor of England and Wales will need to pass, regardless of how they have trained. So it will apply equally to traditional law graduates, as well as apprentices, as well as overseas qualified lawyers. Digging down into a bit more detail, there will be 4 requirements that people will have to make out in order to be admitted as solicitors. They will have to demonstrate that they hold a degree or equivalent qualification or experience. They will have to successfully pass the 2 parts of the SQE, SQE1, an assessment of their legal knowledge, and SQE2, an assessment of their legal skills. They will have to complete at least 2 years qualifying work experience. And this is experience of providing legal services in such a way as to be able to develop your competencies, the competencies specified in the Statement of Solicitor Competence. It will certainly include traditional training contracts, but it will be broader than that. Somebody working as a paralegal, somebody working as an apprentice, somebody doing a year's placement in industry as part of a sandwich degree at university, all of those experiences can count as qualifying work experience. And as at the moment, candidates will have to demonstrate that they are of proper character and suitability to be admitted as a solicitor. Those are the 4 elements. They're not in any chronological order, but they will all need to be demonstrated by point of admission. Why are we doing this? First, and most obviously, a single assessment offered by a single assessment organisation demonstrably provides a fair opportunity to everybody to demonstrate that they have met the requirements on a consistent basis. As well as being consistent, though, the SQE will be a robust and rigorous assessment of the competencies needed for safe practice as a solicitor. Paul explained that that contrasts with where we are at the moment. We have over 100 universities up and down the length and breadth of the land who currently assess would-be solicitors through writing and marking their own exams. They are all different assessments. We attempt to standardise those through the normal processes of having external examiners and so on, but it's not as rigorous and robust as having a single suite of examinations that everybody passes. The new system will provide greater transparency about training quality. We will publish information about performance by training provider in the new exam, so students will be able to take that information into account in deciding where and how to train. SQE is the key which unlocks greater flexibility in how people train. Because we have that greater regulatory assurance in endpoint standards, we can provide greater opportunities in the market for people to train in ways that suit them. It means that law firms can think about recruiting their future solicitors through people who work as paralegals, through apprenticeship routes, through traditional training contract routes, a far greater variety of choice, which we hope enables law firms to spot talent, the most talented people, wherever they should be. We hope that provides flexibility for firms and at the same time provides flexibility for students so that both can train in ways that meet their personal circumstances and, in the case of businesses, their business objectives. Now, a brief additional word about qualifying work experience. It's more flexible. It includes wider ways of training, as I said a moment ago. But one of the things that's key about this is that it must be signed off by a solicitor who we regulate. That can be the firm's COLP. It can be other solicitors in the firm. We will no longer require firms to have a training principle. Of course, if you wish to have a training principle because that suits you, that's fine. You can continue to do that, but it will not be a regulatory requirement. And the key to bear in mind in relation to the sign-off of qualifying work experience is that it's not an assessment of the competence of the individual who you are signing off. It is a declaration to us that the period claimed for of qualified work experience has been completed. Now, where are we in terms of the development of the SQE? You can see from the slide that this is a substantial piece of work which has stretched over a number of years. We are in the middle at the moment of the testing and piloting of the SQE. It will be a rigorous and robust assessment, and it's absolutely right that we spend the time to make sure that we get it right. We've already run one pilot. We piloted it in March. We piloted SQE1 in March, and we're running another pilot in December. We will be taking the learnings from that and using that information to make final decisions about the detail of the assessment design. And we remain on track to introduce SQE in the autumn of 2021. That's when the first live assessments should run. Moving on to continuing competence, you will all be aware that 2015 to 16 we introduced a new approach to continuing competence. That was all about maintaining high professional standards but giving people flexibility in how that's done. As Paul said, we took away the requirement for particular hours of CPD, and what we reminded the profession of instead was your professional obligation to make sure that you do what is needed to stay up to date and safe to practice. We continue to monitor that, and we did a piece of work earlier this year where we did an online survey and we did a thematic review looking at how this was working in practice. And we were very pleased that what that told us, what the firms and the solicitors told us who were involved in that exercise, was that this had gone well for them. It had not proved particularly difficult to implement. And that the amount of training undertaken remained high. 52% of the people who responded to our survey told us that they had maintained the current amount of training that they do. 40% told us that they had actually increased that. And actually part of the reason for that is that the new approach gives people greater ownership of their education training. They can see better how it's targeted and relevant to their particular roles. And people told us that they valued that. And finally, a shout out for our advocacy consultation. We launched this in August and it closes on the 13th of November. We're proposing on a package of changes to how we regulate advocacy. We're consulting on revised standards for the higher rights assessment, on the creation of a single centralised higher rights of audience assessment, and we're proposing to publish a more detailed suite of online resources supporting practitioners in this area. What I would say is please do participate in that consultation. Tell us what you think about our proposals. Tell us if there are particular things that you would like to see included in the information pack. So that's all from me, and I think at that point I'll hand back over to Clive.
Julie, Jane, Juliet, thanks very much indeed for that. I knew that Alan Alexander was a bit dodgy. I knew it. It must have been the lack of information on VAT, on costs and disbursements. Anyway, I appreciate there was a lot of content there that our speakers went over, but hopefully that all helps you get ready initially for the new rules coming in on the 25th of November. If you still have questions, please ask the SRA staff available at the Marketplace stands in Hall 3. Now, there will also be opportunities to ask questions, so don't worry. In the breakout sessions, which start in 25 minutes, and the sessions you're due to attend will be listed on your badge. Some are already full, so it's important to go to the right session at the right time. Now, to our first vote. I think the results are in. Whoa. Right. Anna, what do you call a collection and gathering of compliance officers? A rabble. No. Confused. Ladies and gentlemen, it's time for a bit of a break. Grab a coffee in Hall 3, and we all look forward to seeing you for the breakout session shortly, starting promptly at 11:30. Thank you all very much indeed. Thank you.